All right, my name is Tobias Eisenlohr. This is going to be a presentation about the basics of land use law. It's a field of law I've been working in for most of my career so far. I spent a couple years working for the city of Virginia Beach doing land use, zoning, property maintenance, planning, and I've just moved back to Ohio, started practicing law out here, and I thought I'd give a presentation when I was asked by the Cincinnati Bar Service what I wanted to talk about. Navigating municipal governments and land use law was a topic that came to mind right away for me because I think it's really interesting and something that if you own a home or you own any property, it's something I think is very useful to know about the process of how you get permits, how you can get variances, and the kind of basic law underlying all those systems that are put in place. So the foundations of land use law are kind of based in how the government has any authority to be able to tell you what you can do with your property. It's a pretty American kind of concept. You know, anytime the government is saying you can or you can't do this, people really want to know why that's the case. You've got a Fifth Amendment and 14th Amendment right to property. So when it comes to things like zoning or building codes or property maintenance codes, there's been a lot of litigation through all the way up to the Supreme Court on all these fields for decades to figure out exactly where the contours of when the government can tell you you can or you can't do this with your property. I'm not going to go into all of that because it's exhaustive and I find it kind of exciting, but I don't think it's really worth going into for a topic like this. But the basic fundamental reason is for health and safety of the citizens. This is why the government is entitled to enact land use controls. For example, zoning, which I'll get into in a minute, was one of the original cases that went up to the Supreme Court at a village of Euclid in Cleveland. They enacted a zoning code, and this was appealed all the way up to the Supreme Court. And the argument behind it was, why is the government allowed to say, if you own property in this area of the city, you're only allowed to develop this type of property there? That's depriving me of my right to use my property as we see fit. And the way the Supreme Court ended up deciding on this was there was such an overriding governmental interest in keeping different types of businesses and residential areas separate from each other in order to protect the health and safety of their communities that the government was entitled to do that. So zoning is a big part of land use law. The government can tell you where you can develop things, can tell you you're not allowed to use a parcel of property to do something on it. And the reason why, an example is you could have a school that's right next to a slaughterhouse otherwise. You could have a factory that's emitting pollutants that's right in a residential neighborhood. There's a reason why the government is allowed to separate these zones out. The building code is very similar. You know, you own a parcel of property, you'd like to think, I can do whatever I want with this. And there's a reason why the government is entitled to enact a building code on that. It's because they need to make sure that everything that's put up is done in a safe manner. Otherwise, they just let anyone build a house or a factory or something and it didn't comply with any type of building code. It could collapse, it could put people in danger. The property maintenance code is similar. They can tell you you're not allowed to let your grass grow really long. You're not allowed to let your gutters fall apart because it ends up impacting the other people in your neighborhood if you do that. So those are really the three areas of land use law I'm going to focus on today: zoning, building codes, and property maintenance codes, how you navigate these systems. There are a lot of other things related to property ownership that I'm not going to be dealing with today. There's just not enough time to cover all of it. And these, I think, are pretty fundamental topics that are pretty basic and pretty likely that if you're a property owner and you have concerns about your municipal government, it'll be involved in one of these three areas. So first we'll talk about zoning. I talked about that a little bit, but what is it? It divides up the area the government controls into different zones based off uses that are permitted and uses that are prohibited. And it can also set standards for dimensional requirements, such as your yard setback, your maximum height you can have there, floor size, everything that's really regulating the way that a piece of property within that zone can be developed. There are three really basic types of zones: residential, commercial, and industrial. Now within those, there are a lot of other subcategories. Within the city of Cincinnati, I think there's at least 6 or 7 different types of residential zones. But at the basic level, it's about keeping residential areas and commercial areas and industrial areas to give them their own space within the city, so that they're not all mixed in with each other. There is a large trend now to have mixed-use developments. You can see these, especially in densely populated areas where there will be buildings that have first-floor retail with apartments on top of them. It happens everywhere in downtown Cincinnati. There's special zones for those, and they usually follow a type of zoning that's called a form-based code. But at the really basic level, those are the things that the government is trying to keep separated. Here's an example of what the zoning ordinance in Cincinnati says. This is part of the single-family zone, SF. You can read here what it says, the purpose of it: to create, maintain, and enhance neighborhood residential areas that are characterized by detached single-unit structures with typical lot sizes ranging from 2,000 square feet to a half acre or more in size. It says future development must remain single-family residential in character. There are certain exceptions to that I'll talk about in just a minute. But you can see here there's a few different types of the single-family zoning, and it breaks it down by the lot size. So you can have the big ones at 20,000 square feet all the way down to the 2,000 square feet, and that's the minimum. And within each of these, there'll be restrictions on the setback, so it'll have to be put a certain distance back from the street, restrictions on fences, restrictions on building height, and anything that's developed in there has got to comply with those. And this is an example of the zoning map. You can see here's the city of Cincinnati. We're somewhere down here. I live up there. It's broken down into all types of different zones. Here you can see this is mostly industrial. There's a lot of residential stuff, commercial, and you can just see here how the city is kind of laid out. You can probably tell just from looking at the map what type of zones there are just based off where they are in the city and what you know about the city. You can check your zoning online. You can also check the zoning ordinance. I couldn't help but pull this out. This is literally the graphic that they use for the unincorporated territory of Hamilton County on the front of their zoning resolution. I just got such a kick out of how it looks here. But there's a GIS system that Hamilton County maintains where you can actually check your zoning. I have up here my childhood home at 6966 Weatheridge Drive in Anderson pulled up. You can see it's got a zoning designation of C. You can zoom out and see all the other different zoning layers. And there's a lot of other really useful property information that you can find through this site. The city GIS. Anyone have an address that I'm going to put in here? Try out? Don't have to.
How about 1346 Hurlin Place?
Hurlin? All right. 1346 Hurlin Place. What do we have here? Okay, there's a lot of info about it, and if you go over here, it should tell you the zoning jurisdiction is Cincinnati, zoning type is municipal, and the zoning zone is SF6. So we go back to SF6. It's this middle zone. Minimum lot size is 6,000 square feet. And I didn't copy all the other aspects of the zoning ordinance here, but it will tell you within the zoning ordinance what the setbacks are, all the other dimensional requirements of a single family home in an SF6 district. Now we talk about what is permitted in a zone. I said that in that district, for example, the minimum lot size is 6,000 feet. It'll tell you what the dimensional requirements are. So if you bought a vacant parcel of property and you wanted to develop a single family home there and you had it comply with all the dimensional requirements, then that is going to be by right zoning. There's really three types of uses within a zone. There's the by right, there's the conditional, and there's the prohibited. So if I bought that parcel of property and I said, I want to put a factory here, that's a prohibited use. If I said I want to put a single family home here, that's by right. And conditional uses are the interesting ones, which I'll talk about in just a minute. But you can see here, this is also clipped out of the zoning ordinance. This is within a single family district. So it'll break down up here, we'll say like the different zones, and this shows you something like a public utility distribution system is conditioned, but community gardens are permitted. That means you can just put a community garden in, you don't need any special zoning approval for it. But if it's a conditional approval, you will. By right zoning means you don't need a specific approval, but that doesn't mean you can just go ahead and build a single family home there. You gotta make sure you're complying with the building codes and everything else that I'll be getting to in just a minute. Conditional use permits are really the interesting ones. Conditional use permits allow you to put something in a zone that is encouraged. They want to have things that are that they have put conditions on, but they're more intensive uses than your normal by right developments there. So within residential areas, for example, you can have a school, but a school requires a conditional use permit because it's a much more intensive activity. There's going to be a lot more traffic. It's going to generate a lot more noise. So you can't just develop it by right. You've got to go through a special process where you get approved and you receive your zoning permit to do that. Schools and churches are big ones in residential areas. For commercial districts, something like a wireless communication tower that's going to be really big, that's something you need a conditional use permit to put in. Now, in order to get one, you've got to go in front of the zoning hearing examiner. This is an examiner who works for the city of Cincinnati. They review all the applications for conditional use permits, and they'll let you know if you get approved or not, and if you're denied, there's a whole system of appeals for that. And what's very important about this is they can put conditions and restrictions on that development in order to mitigate the impact it's going to have on the neighborhood. A really easy example of that is the hours of operation. So if I got a conditional use, they could say, well, you can't operate it between the hours of 4 and 6 is very common because that's going to be heavy traffic times. So they want to make sure you're not increasing the amount of traffic in a neighborhood. There can definitely be requirements to have a certain amount of parking spaces. Anything that's going to help mitigate the impact on a neighborhood if you put something in there that requires the conditional use permit. Now we can talk about variances. Variances are even more intense than conditional use permits. A variance is basically asking to have an exception from the zoning ordinance. So it's not something you need a special permit for like the conditional use. You're actually asking to have the zoning ordinance not apply to you in a particular way with a piece of property. It's a deviation from what's permitted in an area. These are supposed to be pretty difficult to get. In practice, depending on what jurisdiction you go to, they're not as hard as the language that's put into the statute makes it seem. But it really depends on where you go. But it's not supposed to be easy to get a variance. You're supposed to have to show that you've got some type of special hardship that's unique to your property. There are two kinds of variances. There are area variances and use variances. The area variance authorizes a relaxation of physical zoning restrictions due to the unique physical characteristics of that property itself. When you ask for one of these, you have to meet a certain standard which says that practical difficulties prevent your reasonable use of the land under its current zoning. Examples of this can be, if I went through an area and I zoned it all residential and it was cut up into a bunch of different lots, and then there was a lot that was kind of on the corner, it had an odd shape, and someone wanted to develop a home there, and they looked at what the zoning ordinance said, and there's no way that they could fit a single family home into this strange shaped parcel of property and meet the required setbacks. There was something unique about the way that this parcel was situated. They can ask for an area variance to say, we want to put our property line or put our house outside of the setback, or any other type of deviation from the area. You can think about properties that have strange topography, like hills. And then there are use variances. Use variances are authorization to have a land use other than one that's normally permitted in that area. These are very rare to get. The standard for a use variance is that you can't make a reasonable economic use of the property as it's zoned. That's a difficult bar. You got to be able to convince the zoning hearing examiner or the Board of Zoning Appeals that you just can't have any reasonable use of this property that is beneficial based off some hardship. Examples of this could be if an area was primarily residential in character and zoned residential, but all around a certain parcel of property, there were a lot of grandfathered in commercial uses or industrial uses. You could ask for a variance to allow you to use that property for a commercial or industrial use because it could not be developed as a residential property. It's not supposed to be easy to get, but you can always take a shot if you think that your property just can't be used the way it's supposed to be in the zoning ordinance or under its current zoning. So I mentioned that these things are reviewed by the zoning hearing examiner. The zoning hearing examiner is an officer of the city of Cincinnati. They conduct public hearings on these land use proposals. So you will go forth in front of them requesting your conditional use permit, requesting your variance. It's a public hearing. The city will put in their own input for it. Anyone who's going to be impacted by the project can put in their input on what they think about the project. So, you know, if you're asking for a variance to let you have a slaughterhouse somewhere, all of your neighbors can come out and say, wait a minute, that's going to greatly impact us as property owners. You can't do that. It's kind of like a trial. You know, you got to present evidence. There's opportunity for opposition. You've got to be able to provide a lot of documentary evidence. You've got to testify about what you're looking for. There's a lot of specific requirements that are unique to the proposal. So I'm not going to try to get into all those. I can advise you can find those on the City of Cincinnati's website. You might want to talk to a lawyer who knows about land use, who can tell you if you're asking for this kind of variance, you're going to need this kind of site plan, you're going to need this impact analysis. Here's everything you're going to need to put together your proposal. And it's going to be a package that's going to cover all the different areas of impact that a proposal will have. What if you get denied? You can appeal that decision to the Zoning Board of Appeals. There's going to be another set of application requirements. You're going to go up and say, I think it was unfair that the zoning hearing examiner denied me. The Zoning Board of Appeals will consider all this. The standard of review, though, is fairly difficult. They're going to be looking not at the proposal itself. It's not a second shot at getting your proposal approved, but it's going to be a review of the zoning hearing examiner's decision. So they're going to look at whether or not the zoning hearing examiner's decision was unconstitutional, illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and probative evidence. It's the reason why I put Jackie Childs from Seinfeld up there, because I thought that this really sounded like the kind of way he talked. He would string together all these adjectives, and they were kind of legal sounding. And I got a kick out of it when I was reading this and preparing the presentation. That's the first thing that sprang to my mind. I could just picture him saying it. An appeal of a ZBA goes up to the Court of Common Pleas, and they're going to review it on a pretty similar standard. They're going to look at what was the ZBA doing. Did they make a decision that was not supported by any of the evidence? Did they make a decision that was unconstitutional, capricious, or arbitrary? And that's a hearing in court. Okay, that wraps up most of what I wanted to talk about with zoning. The next area that I wanted to cover was building permits, which is related to once you got your zoning down, well, what does it take to actually get something built here? If you're going to build something, often you need a permit from the city. What kinds of things need permits? New buildings, additions to existing buildings, alterations to existing buildings, demolition, excavation, new accessory structures. These are the kinds of things that you've got to go through the city to make sure that you're doing it right, and you've got to tell them exactly what you want to do. You got to give them the opportunity to review your plans. Things that don't need building permits are pretty simple projects. Minor repairs to your property, repairs to accessory structures. There are fences, which we'll get into in just a minute. There's some rules about fence permits. But generally, if you're going to be doing something where you're tearing a lot of stuff out or you're getting any heavy equipment involved, you're going to want to consult with the city, at least to see, do I need a building permit to do this? And you can give the city a call, tell them what you're thinking, and they'll let you know if that's something you're going to need. Permit application requirements. Usually, a construction permit has got to be prepared by a registered architect or a professional engineer who can stamp it. And the city is going to want to make sure that you've got someone who knows what they're doing involved in this. What I thought was very interesting, though, is that if you're a homeowner in the city of Cincinnati, you could be allowed to do construction without a contractor as long as you will be occupying the residence for a year after completion. So individual property owners can actually present these plans. You don't need to be an architect or an engineer if you want to build a house. You can even have a relative do it for you, technically, if you're not physically capable of doing it. This is a case-by-case consideration. I put Ron Swanson up here from Parks and Recreation because it seemed like the kind of thing Ron Swanson would do. You know, he would just want to go build his own house. He wouldn't want to have to get an engineer or an architect. He would assume he knew more than any of them, and he would just say, let me do it. I don't have any certifications, but I can do this myself. Or I'll do it for my relative, and I'll get it considered on that case-by-case basis. I would approve him. So there's several steps to the review process. They're going to want to go through a site plan review. So you submit your site plan to the city, tell them what you want to do, and of course then it gets sent out to all kinds of different departments, and everyone's going to want to take a bite at your proposal to make sure that you're complying with all the different areas of the city's requirements. Stage one is your preliminary design review, and that's going to go through zoning, planning, transportation, water, sewer, stormwater, fire, police, health, economic development, and law. Everyone's going to want to take a look at it to make sure you're not doing something that's way beyond or outside of one of their requirements. So everyone kind of reviews this. I used to work for city, and I can tell you that this stuff would get crazy because you would go to a million different departments, so you'd be trying to get this stuff coordinated. As a property owner, I would definitely advise you to stay on them about getting the stuff back to you, because things can go into the void once they start getting sent around. Once you're through that, you'll get your development design review. This is a little bit more specific. Some of the departments, things that run through in the preliminary design may step out at this point. They'll be satisfied that you're not going to be doing anything that is going to impact the fire code or fire department. So at this point, they'll review your utilities. They'll want a site plan that is more detailed with topography. They're going to want a subdivision analysis. So if this is a single family home, they're going to want to know how it's going to impact the rest of the homes in this area. Typically, it's not going to be a problem unless you're asking for like a variance, or you want a 3-family home or a 2-family home in an area that's not usually part of. Once you get through that, then you get to your technical design review. And this is the last stage. You've got your full site plan. You got to have construction drawings, engineered drawings, documentation of all your easements. And once you're through all this, at that point you can go down to your building plan review. This is a 3-tiered review process based off how intense your development's going to be. And there's reasons why you'd go into one of the 3 tiers. They're pretty complicated and they're pretty case-by-case specific. So what I'd say is, if you're at this point already, the city's going to tell you either you get your tier 1 approval, which is very simple to get it back to you day of, or there'll be a deeper review of what you're actually asking to do. There'll be more city hands all over the project, making sure that it's going to be complying with city building requirements. All right, I told you we would talk about fence permits. This is something that's, I think, pretty interesting to the average homeowner who may want to replace a fence. Typically, a fence is something that requires a building permit, but it doesn't seem like it should. A fences over 6 feet in height, you'll need a building permit for. But if they're under 6 feet in height, you don't need to actually go through the building permit review process. However, you are going to need to get a certificate from the city that your fence plan is good to go. If you live in a historic district, that's going to be called a certificate of appropriateness. Most people don't, so this is going to be something called your certificate of compliance. This is a form you can find online. It's pretty straightforward. You just fill out what you want to do, and you submit it to the city along with a site plan that demonstrates where you want to put the fence. This does not have to be an engineered drawing. It doesn't have to be stamped and sealed by anyone. It can be pretty basic. You can just have whatever contractor you want to use kind of draw a diagram of your property, draw where the fence is going to be, write something showing how high the fence is going to be, and it's got to be a certain level of opaque that the city's going to want to look at, but it doesn't have to be, a very detailed diagram. So you send it to the city. Of course, you got to send your application fee too, and they turn it around pretty quickly and they say, here's your certificate of appropriateness. You're fine to build your fence.
Do you have another slide?
Yeah, right here. You mind passing that down? Thanks. Okay, what do I do if my building permit gets denied? This is kind of similar to the zoning denials. You can appeal it to the Board of Building Appeals. That's going to review the decision of the building department to give you a permit or not. It's a 5-member board. They hold regular public hearings. It's like the Board of Zoning Appeals and the zoning hearing examiner, kind of like a trial. You've got to get up there, present your evidence. You've got to say why you think their decision was unfair. You got to testify, give them documents. I couldn't help but use this picture. This is a house in China. These are things that happen when land use controls get a little bit out of control. This is what they call a nail house. You can see there's a road that goes through here, and there's a piece of property right there. And they couldn't find any way to agree on this, so the house just stayed there. They couldn't get rid of it. This happens occasionally in China, so it's just sitting there right in the middle of the road. I just find that so fascinating. You'd think they would have better eminent domain, but all right, that's just about wraps up building permits. The next thing that I wanted to talk about was assessments. This is something a lot of property owners are interested in because it impacts your taxes. The property assessment is going to be levied on your property by the city assessor, the city auditor. They're going to evaluate your property, and they're going to tell you what you owe them in taxes based off of what your property's worth. A lot of people want to challenge this because they want to, people want to challenge these assessments because they want their property taxes to be lower. So how do you do that? You appeal it to the Hamilton County Board of Revision. This is something you got to file between January 1st and March 31st. There is a very strict window of time when you can do that. That's a 3-member board. It's the auditor, the treasurer, and the Board of County Commissioners. The burden of proof is going to be on you. Whoops, I cut that sentence off. But it's going to be upon you to submit evidence that there's been a change in circumstances with your property. That's going to show that something different is impacting your property than it was at the time of the assessment. So maybe your foundation shifted, or maybe part of your property got damaged by something. It's just not worth as much. You've got to be able to get your own assessment to show that something has changed. And you can only appeal your assessment once every 3 years. And if you get denied by the Board of Revision at that point, then you can appeal to either the Board of Tax Appeals, or you can take it to the Court of Common Pleas. It's up to you to choose which route you want to go. If you're not sure which one you want, definitely talk to an attorney who's familiar with the area who can tell you what would make sense for you or what their take on it is. Okay, what if I just don't get a building permit and I do the work anyway? Sometimes people like to be sly and just say, well, I got to go through this process, but whatever. I know how to build a shed. I know how to do this. I'll just put it up anyway. If you do that and the city finds out about it, they're going to investigate it. They're going to charge you an investigation fee. They're going to charge you for the permit they're going to need to get. You need to go back through the process. They could even order the property to be torn down for violating city code. You don't have a permit for it. It's an unauthorized structure. So it's very dangerous to get into that area. Another problem could be exceeding the limits of your permit. This is an example from Virginia. When I worked for the city there was someone who was approved for a single-story detached garage. They got a permit for it. They went through the whole process. And then they had a contractor who said, hey, the city's not going to care. They're not going to come back and check any of this. Just turn it into essentially a 2-story second house. It had a dwelling unit above it. I mean, it was this huge, elaborate garage. And then once their neighbors started complaining that all of a sudden this guy has this huge garage in the property, the city goes through and finds you way exceeded all of your permits. The fight went on forever where they were trying to make it right, but at the end of the day they had to tear it down just because it was so far outside of the bounds of what they were supposed to be doing there. And they thought, just do it anyway, ask for forgiveness and not permission, but that's a very dangerous way to go with the building permit process. And the last topic that I wanted to cover is code enforcement. And this also refers to zoning enforcement too. This is going to be restrictions on existing buildings and properties, how they must be maintained. City code is going to require you to maintain your property up to the standards of the city's property maintenance code. If you don't do that, you can be cited by city officials. These are zoning inspectors or code inspectors. I used to work with these guys a lot in the city of Virginia Beach. And there are many of them that are very hawkish about their job, and they'll be very intent on, they drive around all the time trying to find property violations. The way that this usually works is they'll notice you've got a violation. These are normal violations. It'll be like weeds and rubbish, exterior in disrepair, your windows are broken, your downspouts are messed up, you're harboring vermin, your flues are obstructed. There's tons of potential violations. Pretty much anything you can think of that if you can see it on a piece of property and tell that there's something wrong with it, you could probably get cited for it. Usually they will issue you something called a notice of violation. That's letting you know that the city inspector has seen that the property is in some type of violation. They'll give you a certain amount of time to remedy that violation. If you don't remedy it in time, that's when they can actually cite you, and that's a criminal charge. You'll go to municipal court. Some of them are class 1 misdemeanors. Some of them are unclassified misdemeanors, but you can start looking at fines. I haven't witnessed this in Cincinnati, but in Virginia Beach, I did see people go to jail over property maintenance code violations. Didn't happen often, and it typically took multiple violations on a piece of property, but if you got to that point, I couldn't believe it when any time it happened, but it did happen. So what if you get cited? You can appeal your notice of violation to the Board of Housing Appeals. This is very similar to the Board of Building Appeals, the Board of Zoning Appeals. It's another administrative body that reviews the appealable orders. You have to appeal the notice of violation. If you get the notice, they give you a certain amount of time to fix it. You've got to appeal the notice before that time runs out, because once it runs out and they cite you, at that point it's going to be too late to go back to this appeal process. You're going to have to be dealing with it as a criminal matter in court. These housing appeals, like all of them, are public hearings. They're open to comment by city officials. Your neighbors can come. That's always a lot of fun when neighbors get into these things together. Yeah. And these are appealable to a state board as well. And if you get to the point where you're cited, you go to municipal court. It's a criminal charge, like I said. You get all your constitutional rights of anyone accused of a crime. And the city's got the burden of proof to show that there's a violation. I can tell you as a practical matter, even if you get to the criminal level, I can't promise you this, but if you get a criminal charge for a piece of property and you show up in court and you have evidence that you have remedied that violation, most of the time it will be dismissed. They will not push it against you, especially if it's the first time you've done it. If you got cited for your downspout is in disrepair and you show up and you show your inspector, look, here's pictures, I fixed it, they'll have no problem dismissing it. The goal of these is usually compliance. There are some inspectors who don't like to let things go, But most of the time, when they go up in front of a judge and you tell the judge, look, here's proof I fixed it, the judge will want to throw it out. Can't promise you that, because you're technically in violation at the time of the citation, but most of the time, people don't want to penalize you for this. They just want to get it fixed. All right, that wraps it up for what I had prepared today. If anyone has any questions for me about this stuff, yeah, go ahead.